Everybody knows the drill in answering the roll. Let us know where you're at. Madam Secretary.
Senator Byrd. Senator Carroll.
Present in the room.
Senator Kerr. Senator Neal. Senator Schickel. Senator Schroeder.
Here in the district.
Senator Stivers. Senator Turner.
Here in the room.
Senator West. Senator Wheeler.
Present in the district.
Representative Banta.
Here in the room.
Representative Blanton.
Present in the room.
Representative Bratcher.
Present in Jefferson County in my district.
Representative Cantrell. Representative Decker.
Present in my district.
Representative Fisher.
Present in my district.
Representative Hebron.
Present in the room.
Representative Kulkarni. Representative Lewis. Representative Maddox.
Present remotely.
Representative McCoy.
Present remotely. I am out of the state, though, on official legislative business.
Representative Mentor.
Present in House District 20.
Representative Mosier. Representative Nemes.
Present in the room.
Representative Petrie.
Present remotely in my annex office.
Representative Scott. Representative Stevenson.
Present in the district.
Co-Chair Westerfield.
Here.
Co-Chair Massey.
Here in the room.
All right.
Mr. Chairman, this is Alice Kerr, and I'm remote in the district. I apologize for not answering at the beginning.
Now that you're here, though, Senator, we can begin.
Okay, thank you.
She was a little busy yesterday, I tell you.
We're checking on the quorum here.
We spoke at a Fish and Game Club until almost 10:30 last night. We spoke at a Fish and Game Club.
Is there a motion to approve the minutes of our prior meeting? Motion from Representative Hebron. Is there a second? Second from Senator Turner. All those, any discussion, any questions? Seeing none, all those in favor, please vote by saying aye.
Aye.
Aye. Thank you. Those opposed? Seeing none. All right. Moving right along, we're going to go in order of the items here on the agenda, I believe, this morning. We're going to go ahead and call up our first group from Louisville Metro Government. We've got Jennifer Green, the board chair, who I believe is with us this morning. Come on up. And I believe Mr. Harness, the brand new Office of the Inspector General, Mr. Harness is attending remotely. I see him there. I'm not sure who, Ms. Green, if you or Mr. Harness want to speak first, but you have the floor.
Okay, can you hear me now? Perfect. And we do have a PowerPoint presentation that I believe was circulated in advance. Okay.
Does it have audio?
Wonderful. Well, hello everyone. My name is Jennifer Green. I am so excited to be with you today. I have the honor and the privilege of serving as the inaugural chair of the Louisville Civilian Review and Accountability Board. As Senator Westerfield mentioned, I'm joined today by our newly approved by Louisville Metro Council Inspector General, Mr. Ed Harness. In terms of my professional life, I serve as Vice President of Global Mergers and Acquisitions at Yum Brands, and I've been with Yum for about 6 years now. Today, I really just want to share a little bit about the journey that we've been on in Louisville with the Civilian Review Board, and demystify a few things for this audience and just give you all a flavor for the type of people who have stepped up to the plate and raised their hands to be a part of this very important initiative in the city of Louisville. So I'll start just with a little bit of background. I know many of you are intimately familiar with the genesis of the board and some of the events that led to its creation. What you see on this slide is just some high-level background and information that kind of informed the working group as it was thinking about how to build bridges between law enforcement and the community in the city of Louisville during a period of, I'll describe it as unrest and a degree of turmoil. And so that working group, and we'll talk a little bit more about it later, sort of collectively came together, researched, looked at best practices, surveyed different models across the country, and through their collective wisdom, arrived at the creation of our form of civilian review oversight in the city of Louisville. If you flip to the next slide, this is just additional background on how the model has evolved over the years and how that has, we'll talk a little bit about how that's translated into what we're doing in the city of Louisville. As I mentioned, the working group was comprised of a cross-section of the city of Louisville, lots of civic, social, religious, and spiritual interests, political interests represented in that group. And they really came together. It was a group led by my personal councilwoman, Councilwoman Paula McCraney, and Ellen Hessen in the mayor's office to debate, research, and recommend the best structure for how we want to do civilian review oversight within the city of Louisville. Let's see. The working group was comprised of approximately 33 individuals, and that working group recommended what they described as a hybrid model to bring to life civilian oversight within the city of Louisville. And really what I think that means is the Civilian Review Board in Louisville, it is largely an advisory board. It plays an advisory role. I think there's sometimes the perception that we are making decisions that implicate officers' freedom, liberty, their ability to remain gainfully employed. And I just want to highlight that we are very aware of, the four corners of the ordinance that gives us our power of oversight and have no intention of crossing that boundary when it comes to reviewing matters brought before the board. So the working group's efforts culminated with the ordinance that was signed into law in November of 2020. I think I touched on this. The spirit of the board is really to increase just regular everyday citizen involvement in police oversight. It's sort of it's a social and societal signal that the police are not policing themselves, that there's a second pair of eyes that are involved in reviewing matters of police misconduct brought forth through a formal complaint process. In addition, the board's role, it's one of oversight of the Office of Inspector General. So I'm excited that Mr. Harness is with us now. There's a lot of work to be done. He's got a very steep ramp up in his first 90 days because our goal is to put into effect all of the great thinking, the diverse cross-political, bipartisan thinking that went into putting this board into effect, all with a view of giving ordinary, everyday citizens just kind of faith that when they lodge a complaint against law enforcement, that there's somebody who's outside of the sort of core infrastructure that's taking a look at that. So this slide really just kind of list out the key powers and duties of the board. I kind of touched on this. I won't read this line by line, except to emphasize that the entire board is very familiar with the scope, remit, limitations, powers, and duties of the body that we have collectively come together to participate in, and we're respectful of all the thinking that sort of formed how we are to interact both with law enforcement and with the mayor and Metro Council, and we have every intent of following this guidance to the black letter of the ordinance. This next slide just lists out, and I apologize for the animation. I'm just going to keep clicking through. It lists out the inaugural members of the board. There are 11 of us. For those who are not familiar, we all came to the board through basically 3 different routes. A group of us, I believe 3, were submitted to our council people, and the Metro Council nominated a group of individuals to the mayor, 3 of which would be members of the inaugural board. Another 4 nominees came from a cross-section of working groups within the city of Louisville, which includes groups like ACLU of Kentucky, GLI, the Interdenominational Ministerial Coalition, NAACP, Urban League, YPAL, Louisville Bar Association. So there's 4 individuals on the board who came out of that nomination pool. And then there's another 4 that came through direct nomination to the mayor of the city of Louisville. That's Greg Fisher. There are people from all political walks, a cross-section of professions, perspectives, outlook, race, sex, ethnicity. I am very proud that the Metro Council and the mayor put together a group as diverse. We've been working largely virtually during 2021, yet I think we've had an opportunity to interact in person on at least one occasion. And I think, as you guys have probably discovered during COVID, relationships can be forged and bonds can be deepened virtually and through text and telephone, all those things. And it just requires a little bit of extra focus, intention, and effort. But I'm very proud that we have coalesced, and we're excited to get to the business of the board. Just a very sort of high-level timeline. I think I mentioned that the ordinance was signed in November of 2020. Our first meeting was April of 2021, and I'm told this was right after the end of your last legislative session. Between April and now, we've gone through countless trainings, and that's later in the deck. In person, we've spent about 8 to 10 hours with LMPD, doing simulation training, really trying to understand what a fresh recruit coming into the force would experience. Of course, you can't condense, 6 months of training into 8 hours, but I think we walked away from all of that having a lot of respect for what law enforcement does and all the training and credentialing that they have to go to before they're even allowed on the street. In addition, each of us had to do 24 hours in total of ride-alongs, and this really was, I think, transformative to a lot of people. In addition to just kind of seeing what a typical day is, which I think many members of law enforcement would say, there is no such thing as a typical day. We also got to engage in dialogue, and I think, demystifying to the officers who had heard different things or imagined things that maybe perhaps allow their imagination to run away with them, to just see that, we're people and we want the same things, and we put on our pants one leg at a time, and we're all here because we are, committed to the mission of strengthening community and law enforcement relations and bringing transparency and visibility into the perspectives of a cross-section of the community, including law enforcement. So those conversations were incredibly helpful, and I think have done a great deal to hopefully help manage the change within the force in terms of introducing an additional layer of oversight that they rightfully probably have some hesitations about, to say the least. And then lastly, I mentioned that we went through a series of trainings, and I'm an attorney by profession and training, so it was great to be re-immersed in all of these topics and hear from actual practitioners as opposed to just professors in the ivory tower. So with that, I'm going to turn it over to Mr. Ed Harness, who's on Zoom with us today. I am so excited that Ed was formally approved by Louisville Metro Council last Thursday, November 11th. He comes to us from Albuquerque, New Mexico, where he was the executive director of the oversight agency there. Prior to that, he was in private practice for over a decade, and he also is a prior member of law enforcement and the armed services. Ed, I think, was a member of the Milwaukee Police Department earlier in his career. So with that, I will turn it over to you, Ed.
Good morning, everyone. I'm happy to be with you via Zoom at this point. Next time, hopefully, we'll be in person. I want to say I'm grateful for the opportunity here. Very excited about the chance to be with the Louisville Metro Office of Inspector General, and I can't wait to get to work. As Chair Green pointed out, my background, I have been the executive director of the Albuquerque Civilian Police Oversight Agency for the past 6 years. Albuquerque has been operating under a consent decree from the Department of Justice for the past 7 years. And as a part of that, our agency was being monitored as well. Previously, in one of the slides, it was pointed out that there are no oversight organizations that are uniform. They're all quite different. I have experience in two types of oversight organizations, a hybrid, which we did in Albuquerque, much like we'll be here in Louisville, doing review and also conducting investigations. I understand that we're going to broach some topics today regarding oversight and the powers of the oversight agency. So I'll be happy to answer questions as best I can. Having only been to one review board meeting at this point, I'll be looking for them to help me define how we conduct our business. But again, I'm happy to be here with you today and look forward to getting to work.
Thank you, Mr. Harness. Thank you, Chair Green. I appreciate it. Any questions for these presenters? Senator Carroll.
Thank you, Mr. Chairman, and thank you for the presentation today. And I don't think it's any secret that I'm not a big fan of what's going on in Louisville with this advisory board or review board. And I think you said the key words to me earlier when you said it mainly is operating in an advisory capacity. I wish it had been established that way, where there is an advisory capacity up front rather than being in a review panel. And, you know, the concern is that even though you say that what comes out of this will be recommendations, without doubt there will be pressure on the upper administration to follow the recommendations. And so I think there's a little bit more force perhaps than what is, what I heard today. It may be a recommendation, but there are obviously implied expectations that the leadership follow these recommendations. Maybe not so much from the board, but in the public's eye there will be. And in my mind, this is a situation that should have been addressed by Louisville Metro itself. The change in culture has got to come from within the agency. And I think setting up an advisory panel that is formally there and always there to advise, to provide input from the community, I think that would have been a much more productive way to do this, and perhaps not been so difficult maybe for the officers to accept. Louisville Metro has a good police department, and they have problems, and I think everyone will agree with that. I think most of the officers will agree with that. But we have got to make sure that they have the ability to change what's going on, because I think that's where the true change will take place, is within the ranks of the officers themselves. And so I like the attitude, I like the tone that you're taking, and to me it's a little comforting what I heard today, and I appreciate that, and I hope that I'm wrong, and if I'm wrong, I'll be the first to admit it, and I hope that good things come out of this. I hope that Louisville Metro gains the trust of the community back. I hope the community starts to support the police department again, and those relationships are once again in a positive direction. So I do appreciate the efforts, but I'm still very skeptical of this at this point. I have 24 years in law enforcement. Many of those years were spent as an internal affairs investigator, a few of them, 3 or 4. So I do understand the issues, but I also understand that working in a police department, the change has got to come from within. Police officers do not like being forced to do things. So I would hope that the city of Louisville makes the officers as much a part of this process as they possibly can as the community heals from the events of the last year and a half. One question that I have for you, and I'm sorry for taking so much time, with the board itself, is there a particular officer or the review division within the agency, LMPD itself, that acts as kind of a liaison with the board, between the board and the police department? Because there are often distinct policy issues and things that are unique to Louisville Metro that the board's going to need information on as they hear complaints and as they make recommendations.
And I'll take that one. First of all, thank you, Senator Carroll, for your comments. I appreciate your perspective. I have been working very hard to forge a relationship with Chief Shields. I have interacted with, I'm blanking on the woman's name, but I believe it's basically her first deputy. I have routine interaction with a gentleman by the name of Lieutenant William Vogt within the LMP agency, but I think your point is there probably should be some sort of informal to formal connectivity to ensure that we don't have any blind spots when we're thinking about discrete matters. And I will take your recommendation under advice, and we'll circle back with the chief to see if there's somebody within her organization who she'd like to delegate to play that role formally.
I feel like that would be valuable to the board to have that input on certain policies, procedures within the agency that may clear up some things before it goes to a higher level.
Yeah.
Okay. Thank you so much for the presentation. Mr. Chairman, thank you.
Thank you, Senator. Representative Blanton.
Thank you, Mr. Chairman. Ms. Green, thank you over here to your right. Thank you so much for your presentation. And I will echo the comments and the recommendation by Senator Carroll, myself also being retired law enforcement here in Kentucky from the state police. I'm glad to see that it's been presented as an advisory role as well. It's one of those things that I'm also fearful for outside influence if things were to happen on you all as the advisory board or accountability board that you may face. I hope that as they look at certain situations that they will gather all the facts rather than deal with social media information and quite frankly even media information, but get to the facts. Oftentimes we've seen, regardless if it's involving law enforcement or someone in our community, when facts come out at trial, it'll be different than what maybe we thought beforehand. So I hope that's taken a look at very strongly. I'm just really concerned. Also, this serves as a potential. I think your hearts are in the right place. I really do. But I also know this serves as a potential of causing some individuals that may go into law enforcement or may want to come to LMPD to think twice about it because of unfortunately, of things they've seen in other areas with these type of boards. And what we're seeing already is we're seeing a very big turn of people no longer wanting to go into the profession. I had a young man that told me himself that he wanted to go into law enforcement, and this is a good young man. But he said, I've decided I'm not going to do it because I don't want to be sent to prison for doing my job. And so I'm afraid what we're building is a environment that's going to discourage young men and women that may want to pursue a career in law enforcement out of fear that by doing things right, and the majority of the police officers really try to do, it's like every other profession. Are there bad apples in the barrel? Absolutely, there is. And we try our best. That's why Senator Carroll and I have both carried legislation to try to rid ourselves of bad actors in our law enforcement community here in the Commonwealth. But what happens when we begin to see the good people no longer want to go in it? There's still going to be people that's going to go in it. And what you're going to see is you're going to see an increase because we're lowering our standards to get people, because we got to fill those shoes. We lower our standards, we're going to get people in there that's going to be problems for our communities, people that we normally would not have taken. And I think this thing can backfire on us if we're really not cautious. Now, one thing I would add as a recommendation as well, besides the liaison with the LMPD, I would really think very hard about the board seeking someone that has law enforcement experience. Now, I'm not talking about somebody that's green, and they don't have to be from LMPD, but someone that has a background, maybe even somebody that's retired from another agency, another state, that when the board is meeting and you're discussing topics dealing with law enforcement and what they do, that will have a voice, but also be able to advise on how things may operate when you're out in a given situation. You know, law enforcement is a profession more than any that people who have no experience, that's never been faced with a situation that our police officers are put in to make life and death decisions in a split second. And you know what? Sometimes they're the wrong decision, but how many of us, when we've had time to think about things, have still made the wrong decision when we find out more information or later? And so we're armchair quarterbacking them really harshly for split-second decisions. Oftentimes, and you don't see it on TV, but those officers are scared sometimes when they're in that situation, and they're trying to survive. They want to live. And so I would recommend that someone that has some experience that can be a benefit to the board to help say, okay, here's what they may be experiencing, they may be going through that's been there. It would be like me putting together a civilian accountability board for any other profession, let's say for doctors, and I'm going to sit in there with no experience whatsoever in heart surgery, and all of a sudden I'm going to question a doctor's decision when things go wrong on that table of the decision they made to try to save a life. You know, and I just think you need somebody there that's walked in the shoes that can help guide you all when you're brought into certain situations. And if it's a good officer, here's what you'll find. They'll be the first ones to tell you, if it was a good officer, this person acted wrong, they were out of line, and something needs to be done. So I would just, you know, I'm going to sit back and I'm going to watch cautiously. I hope that Louisville's Civilian Review and Accountability Board becomes the standard across the nation if we're going to have these things. And so I sat back and I wish you all the best of luck. I want you to be successful. I don't want you to fail, because if you're successful, it accomplishes what you're hoping in your heart for it to accomplish. So thank you, Ms. Green. Thank you, Mr. Chairman.
Thank you, Representative Blanton. I appreciate that.
Senator Berg.
Thank you, Chairman, and thank you, Chairwoman Green, for being here today. This has been a very interesting subject. I'm going to try to make an analogy, and I'm going to ask for your all's wherewithal with this, because I don't know how good of an analogy it is. But you know, I'm a healthcare provider, and I can remember, probably 25, 30 years ago, when we were doing film screen mammography. And most people in the country were trying to do it right. but some places were doing an absolutely abysmal job, to where you would look at these images and they were completely non-diagnostic. And people were dying because these were screening and diagnostic mammograms on women looking for breast cancer. And the people who were doing such a bad job were hurting people. And what happened, they came in federally and they, to the freaking degree, told us what temperature your processors had to be at, how many films you had to run before you could do a screening mammogram, exactly what your KVs and your MAs. And those of us who were in the business at the time were like, oh my God. I mean, these people don't even read mammograms. They're coming in and telling us to the degree exactly what we're supposed to do. But the truth is, they were right. And the quality of film screen mammography, which we no longer use, we're now digital, but the quality of film screen mammography increased drastically across the United States. And I can remember being the professional who said, we don't need these people. This is crazy. This is invasive in my work. But the truth is, we needed it. We needed it not because of those of us who were doing a good job. You refer, sir, to good officers. You get a good officer. There's an implication there that there's a bad officer that you could have chosen. And that's what we were doing with Film Screen. There were people who were doing it right, and there were people who were doing it so wrong that we needed that oversight. The profession as a whole required it. So this is, I don't know, I hope my analogy is you all are understanding it. But for those police officers in the room and those police officers who are listening, I understand the feeling. I was there. I was like, what are we doing? This is time. This is money. This is energy. Those of us who are doing it right should be left alone. But the truth is there were too many of us doing it wrong. So I applaud what you're doing. I hope this analogy makes sense and maybe gives a little bit of peace to some of those people who were so concerned. Because we made it through that whole process. It improved the process. It actually saved lives. It made a difference. It was necessary. So thank you for what you're doing.
Representative Bratcher, and if I can encourage folks, for the sake of time, to get right to the heart of your question. If you've got a question, if you've got a comment, and I appreciate the comments that have been provided by all three legislators before just now, but we need to, if there are questions, we need to get to questions first. If we have time for commentary or comments or remarks after that, we can. Representative Bratcher.
Thank you, Chairman. Can you hear me?
Yes, sir, we can. Go ahead.
I'll get right to the point. I'm from Louisville also, as Chairwoman Green is, and I admire her work. I don't think we've really properly met before, but I appreciate her hard work on this and many other issues in Louisville. And I'll keep it, I just have two questions, and I'll just get right to the first one. We've heard issues about this board is called the Civilian Review and Accountability. Now, I'm all for as much review as we can foster. I mean, everything we do needs to be reviewed by as many people as we can find. But the accountability part, number one, I'd like you to talk about what do you mean by accountability? I mean, we have an elaborate court system. We have a Metro Council. We have an elected mayor. How much more accountability do we need from a civilian board? I wish you would drop that word and just call the board a review, because, like I said, I'm all for review. And number two, Chairwoman Green, how much, when this ordinance or law was created, how much credence was given to where the people on the board live? I know I represent Fern Creek, Highview, parts of J-Town. I don't know if there's anybody in my area even on that board. Was any regional geographic areas considered on who would sit on this board? I don't know, and that I'll be learning when you describe that one. So the first question is, what do you mean by accountability? And number two, geographic areas. And again, I want to thank you. I think you're an excellent council person, and I hate to see you leave, But I've heard that you're getting ready to retire after this term, but good luck to you, and please answer those 2 questions. Thank you, Mr. Chair.
Thank you, Representative. I think you're actually referring to my sister, Jessica Green. So I will send your regards.
Oh, no,
kindly.
I'm sorry.
And I fully appreciate your questions. Unfortunately, I am not in a position to answer them since my involvement with the board it was subsequent to all of those questions being fleshed out, like the naming of the board and selection of candidates. So I will. I've made a note of your questions, and I will follow up if that's okay.
Man, I got egg on my face. I'm so sorry, Ms. Green. Sorry.
No worries.
Thank you, Representative Nemes.
Thank you, Mr. Chairman. I have some of the same questions that Representative Bratcher has. I would note that we have a lot of civilian review. It's the city council, it's grand juries, and it's pettit juries. We have those as well. I really am interested in the geographic makeup of the board. I'm also interested in the partisan or ideological makeup of the board as well. I don't know how you can identify that other than partisan. Last question, the question though, Mr. Chairman, is this: when a police officer is charged, like I said, civilian review, we have it, grand juries, pettit juries. When they're charged, they have the right to defend themselves. We're seeing what's going on in cases across the country even today, but how important it is to actually see the facts as you have the cross-examination, the opportunity to be heard and to present your own side, how it kind of changes the views of things. Will an officer have the right to be present? Not requirement. Obviously, you don't have subpoena authority, but will they have the right to be present and represented by counsel to set his or her side of the story before the board? Thank you, Mr. Chairman.
Ed, would you mind talking about how this was handled in Albuquerque as just an example of the thinking you would bring to the Louisville board? Are you there, Ed?
Mr. Harness, can you hear us? Is he still with us? He's not there anymore, according to our review of the Zoom room.
Okay. Well, my apologies. And thank you, Representative Nemes. I have a law degree, but I'm just an ordinary citizen. And it's been a very long time since I've thought about things like standards of review and, policies and procedures. So I would kindly defer to and rely on our new IG's expertise to lead us and guide us in that way. But I think your point is you're talking about due process, right? And I think
as the chair, do you agree that it's important that the police officer under review have an opportunity to present his side of the case?
I don't want to speak prematurely because we don't have any processes or procedures in place, but philosophically, no. I don't object to somebody having an opportunity to defend themselves.
Okay, I'm interested to see how any review or any investigation into an individual's conduct without having given that person an opportunity to defend him or herself, how any of that can be legit at all. Anyway, I look forward to that answer, maybe in writing or offline. Thank you, Mr. Chairman.
I see, Ed, you're back. Did you drop off for a second there?
He's back.
I did. I apologize. I switched over to my phone, so hopefully this will be more stable.
No worries. Ed, we got a question from Representative Nemes about it's broadly due process, meaning if a complaint is lodged against a member of law enforcement, should they and do they have a right to be present to defend themselves, including by engaging counsel to represent their interests? And my question to you was, can you tell us how that has worked in Albuquerque? We have actually not reviewed a single complaint in Louisville, so I don't mean to be coy, but I just have no experiential basis from which to say anything rooted in facts or reality. So, Ed, would you mind addressing that?
Absolutely. I appreciate the question and I apologize for my internet issues today. It's windy here in Albuquerque, and during the fifth season, the windy season, sometimes the internet gets a little bulky. But absolutely, the officers will be afforded all procedural due process in accordance with their collective bargaining agreement and all other procedural due processes as being a Metro Louisville employee. In Albuquerque, whenever an officer is interviewed, they have a representative with them. Normally it's somebody from the union, but they also can choose to have their legal counsel with them if they choose to do so. They are also provided a copy of the complaint so they can know exactly what those allegations are. And then at the end of the investigation, they are provided with the findings as to what, by a preponderance of the evidence, was the finding of the investigation. So absolutely, the officers are entitled to all procedural due process and representation throughout the entire investigation.
Is that responsive, Representative?
Yes, sir. Thank you. And I assume you'll be moving to Kentucky.
Yes.
We have better energy costs, a lot of water, and I guess the wind isn't as bad.
Absolutely. I'm going to try to get there as soon as I can. I had my last day with the Albuquerque CPOA on Monday. And it was a site visit with monitors and the DOJ. And so I thought it was important for me to do that so I could smooth the transition to the new interim director.
Well, Mr. Harness, thank you. I appreciate you making time. Chair Green, thank you. I appreciate it. As you can tell, we've got some thoughts and opinions about how this board ought to function, or whether or not it should even be, from the members of this committee. And it's come up as a result of discussions about subpoena authority. And I know that in Albuquerque, I believe Mr. Harness mentioned this, but they, under the consent decree, they have that authority there as a result of that. But it's been of some debate here, because the only institution in state government that can grant that power is the one that these folks serve on. And so we appreciate your time, appreciate your input. I suspect the issue will come back up again. I do want to ask, Chair Massey asked this, or wanted me to ask this, so if I botch this, Chairman, you feel free to correct me. But if the board comes up with or produces some sort of annual report of some kind, I was wondering, Chair, if you'd be willing to share that with the legislature, if not specifically the entire General Assembly or the LRC, perhaps just the Judiciary Committee and its membership. You can direct it to either Chair Massey or myself. We'd be interested in staying in the loop there.
Absolutely, 100%. I'd be happy to do that.
Thank you, Chairwoman. I appreciate it. Thank you all so much. All right.
Thank you.
Our next presentation, our friend Representative Patrick Flannery with House District 96, and he is joined by two of our committee's friends, Stacy Tapke, county attorney from Kenton County and the current president of the County Attorneys Association, and our friend Alan George with the Kentucky County Attorneys Association and the Woodford County Attorney himself, also no stranger to this committee. Glad to have all three of you. We're here to talk about DUIs, right?
We are.
Representative, you have the floor, sir.
Thank you, members of the committee, Mr. Chairman. Joined today by Stacy Tapke to my left, the Kenton County Attorney, and to my right, Alan George, the Woodford County Attorney. I'm working on a bill that I do plan on pre-filing. We have a working draft, and I hope to have that pre-filed in the next few weeks to sort through some of the language. So why do we need DUI legislation? A few months ago, the Kentucky Supreme Court had the McCarthy decision. The McCarthy decision dealt with refusal of a blood test, and it was based upon the Birchfield versus North Dakota decision from the U.S. Supreme Court, I believe, in 2016. So this is in response to a Supreme Court decision, and that's why we need it. How do we plan on going about this, and why it's important? Currently, under this case law, a refusal prevents any evidence from being submitted to a jury. So, what we're planning on doing, the concept is to currently statutory law does not allow a search warrant on a DUI case unless there is a death or physical injury. We're going to strike that, and we believe this will be the best way to tackle the problem. A lot of times when people think of DUIs, they think of alcohol-related DUIs. Really, drug driving is probably on pace, if not more problematic than alcohol-related DUIs. And when you try to test someone, you've got primarily three ways. You've got a breathalyzer or an intoxilizer that can be performed. You have a urine test and a blood test. Well, under this case law, it's going to cause and is causing serious problems with primarily with drug driving, because those refusals are thrown out on the blood test. A blood test is what is needed for drug driving. So it is important. I hope to have this pre-filed to give all the members of this committee and other members of the General Assembly an opportunity to review this legislation. And I believe Mr. George has some comments, and then Ms. Tapke, if there's anything else you'd like to add.
Thank you, and thank you for allowing us to appear and be heard today. Thank you. Again, I'm Alan George, Woodford County Attorney, and I've been prosecuting DUIs literally now for over 40 years, beginning as an assistant prosecutor in 1981. Obviously, I'm old, so I won't be doing a PowerPoint presentation, just speaking briefly. I'm here on behalf of the Kentucky County Attorneys Association as we seek to have you amend our DUI laws to allow law enforcement officers to obtain a search warrant when the offender refuses a request for a blood test. This is not a novel concept, but one which is now a matter of grave concern. Thanks to the General Assembly, Kentucky has passed impactful DUI legislation, including the lowering of the alcohol per se limit to 0.08, the 2010 DUI drugs per se law, and most recently the ignition interlock law. While that's the good news for DUI prosecution, I'm here today to talk about the bad news, the Kentucky Supreme Court's McCarthy opinion rendered April 29th and its already devastating impact on DUI drugs prosecution in Kentucky. The McCarthy case holds that going forward, prosecutors are now on notice that a DUI arrestee has a constitutional right to refuse a blood test, and his or her decision to refuse to submit to a blood test cannot be testified to by the arresting officer, so the refusal can no longer be introduced as evidence, nor can it even be commented on by a prosecutor. I'd ask you to remember how Clara Peller asked in the famous 1984 Wendy's commercial campaign, "Where's the beef?" Well, jurors in blood test refusal cases are now wondering, where's the test? Our fellow prosecutors are already seeing jurors render not guilty verdicts in such cases. When a prosecutor recently asked a juror on a panel that had returned a not guilty verdict what could have been done differently in prosecuting the case, the juror simply responded, "No test, no conviction." A DUI charge is the only criminal offense in our penal code for which a search warrant cannot be obtained upon the requisite showing of probable cause. We have to show probable cause plus death or injury. Why are DUI offenders given this protection, which goes above and beyond the protections even someone charged with the capital offense of murder is afforded? This restricted, limiting language is needless and frankly inexplicable. According to the most recent Mothers Against Drunk Driving report, 34 states already allow for search warrants without any conditions in the event of a blood test refusal, including all 7 of our bordering states. We hope that Kentucky will join the ranks of other states by allowing a search warrant in all DUI cases, not just in those cases involving death or physical injury. Which, by the way, those are the rarest of cases. Most DUIs, thankfully, are garden variety, with the stop resulting from speeding or bad driving or something as innocuous as expired registration. But right now, we cannot get a search warrant for a blood draw in those cases. And this is why that's important. We want to be able to successfully prosecute these cases where we currently cannot get a search warrant in the hope of preventing the type of later tragic DUI where we can get a search warrant. By then, it's too late. The human damage has been done. We want to be proactive and preventive in our DUI prosecution and not just reactive to a fatality which perhaps could have been avoided. Here's the other thing about getting a blood test. As prosecutors, we are sworn and we must and do vow to seek justice, not necessarily convictions. The blood test results could actually exonerate a defendant, and if so, we are bound to cease that DUI prosecution. While the search warrant component is the main thrust of this legislation and our primary concern, the McCarthy opinion dictates that other changes be made in KRS Chapter 189A, particularly as concerns our DUI implied consent law and other changes which the legislation will address. Why the urgency? The safety of our roads and thus the safety of the citizens of the Commonwealth and those who travel through this great state of ours is at high risk. We need this change now in this session and hopefully with an emergency clause. In 2020, 43% of the 16,749 DUI arrests made in Kentucky involved only drugs, and another 11% involved a combination of drugs and alcohol. So drugs were a factor, at least in part, in 54% of Kentucky's impaired driving cases. There were 173 deaths in the Commonwealth resulting from DUI collisions in 2020, and 80 of those fatalities resulted from a DUI drugs-related case. Those are powerful, sobering numbers. And speaking of powerful and sober, I was made aware by Jefferson County Attorney Michael Connell, who's here with us today's office, of a situation they're dealing with in Jefferson County. 42-year-old woman was arrested on November 7th for obviously impaired driving. The PBT showed no alcohol in her system, so they went for a blood draw. She refused. She was given a court date 3 days later, November 10th. That morning, that very morning of November 10th, before she was to appear in Jefferson District Court, she was driving, allegedly impaired, the wrong way on a highway in Oldham County, crashed head-on and killed a 16-year-old girl, a young woman, on her way to school. That young woman's sister was in the car with her. She is in critical condition as of this past weekend. They're awaiting the toxicology reports in that case. That's what we're dealing with, and that's what we're trying to avoid. We truly believe if this one simple fix is made to delete the requirement that there must be death or physical injury to get a search warrant, most offenders will end up taking the blood test because they will be told if they refuse, a search warrant will be obtained. So they can do it the easy way or the hard way. Either by consent or search warrant, though, we will then be able to determine what, if anything, they have in their system. We already have the fourth highest rate of refusal in the country. And this is one category where we don't aspire to be number one, but we're heading in that direction without this change. Every prosecutor here today can and would attest we have already seen a dramatic and alarming uptick in blood test refusals since the McCarthy opinion came down. And that it's because this is how it works. Under our implied consent law, the DUI offender is given 10 to 15 minutes to contact an attorney. Any and every defense attorney worth his or her salt is going to tell that person, do not take the blood test. And so they won't take it. And our DUI hand is then busted. We have, in all likelihood, a losing DUI case. And all we're asking for is a fair case. In my opinion, enough is enough for these DUI drug offenders. How many more people are to be hurt? How many more lives are to be lost because of them? We're simply asking that you help us in our efforts to have a fair shot in curtailing drug driving. And we would be happy to answer any questions you might have about the proposed legislation. Ms. Tapke may have some comments first.
I would just add this for the Kentucky County Attorneys Association. This is definitely a high priority. Alan George very effectively explained to you why, so thank you for your consideration of any legislation. Thank you for looking out for this important issue.
Well, I appreciate the presentation. I fully support the bill. I remain stupefied why an investigative tool that the search warrant is, in literally every other kind of case, we would say, you know what, you can use this in any case in the world except this case over here, unless these factors are present. You can use a search warrant any other time, except for that, and I think that's dumb, and it does tie your hands. And it makes you, in the case you just cited, and I wasn't aware of that case, But the case you just made reference to is exactly the kind of case that this could have stopped. You could have gotten the sample 2 or 3 days prior of someone who's clearly got an issue with substance use that needs help, but importantly also needs to be off the road and out from behind the wheel of a car. So I fully support it. I appreciate the association bringing it and Representative Flannery bringing forward the bill. We do have a couple of questions, and we'll get right to it. Senator Carroll.
Thank you, Mr. Chairman. I'll be brief. Representative Flannery, started looking at this the day I heard about the decision, so I'd like to talk to you about helping out in the Senate with the bill. I received an email, and I'm sure everyone else did too, from a prosecutor. My understanding is this case is going to be appealed to the United States Supreme Court, hopefully, or through the federal courts. And there was some concern about not doing too much in a bill here within the state. Do you all agree with that?
We, if I may address, I received a forward of the concerns that were addressed. It is my understanding that this will be appealed. In fact, it already has been appealed to the United States Supreme Court. We were very aware of that, and we have proposed language that would address the issues concerned by that prosecutor and would definitely address the current need and also not get in the way of any any appeal to the United States Supreme Court.
If I may respond also in part, the McCarthy opinion, though, is not stayed. So that is the law in Kentucky right now. Obviously, we held out hope at the Kentucky Supreme Court level, didn't get it. I don't know that we'll get it at the United States Supreme Court level, but we are bound to follow the McCarthy holding unless and until the United States Supreme Court agrees to take it up.
Sorry to interrupt. Has cert been granted?
No.
No, my understanding is the Attorney General's office sought this to be reconsidered by the Kentucky Supreme Court, and that was denied.
Right.
My understanding is that they are taking it to the United States Supreme Court, but I don't believe that anything has been decided there. And as you well know, who knows what they'll do.
Yeah, so they may not take it at all.
They may not take it at all, and so we have been working on legislation that would address all the issues that we can address at this point in time.
Thank you both.
Excellent. Thank you, Mr. Chairman.
Yes, sir. Senator Turner.
Thank you, Mr. Chairman, and thank you all. I read that decision as a good friend there, the county attorney from down the road. I started practicing in '78, and I've defended many of these DUI claims. It's my understanding from the law that, was it Wisconsin, Minnesota case that came down in 2018, the United States Supreme Court said before you can have a piercing of the body to take blood, there must be a search warrant. And that's where that case came from. Then the Kentucky Supreme Court took up the issue in a case, and that might be the case you're referring to. I'm sorry I don't remember the names, but I did research this here a few weeks ago and got the law summary and read it, and says just what you said, that you cannot use the refusal. Then also, with a good representative, I'd like to get involved in working with this. And you need to get the statistics so we can do some remedy of these people, and I use that word openly for the whole state, that get charged and get arrested and taken to jail, and the blood comes back zero after they've spent 5 to 7 days in jail and lost their jobs. And I've seen plenty of them. There's one officer in one county that's got about 40-some. That's all zeros. I had a nephew that the officer said he had something in his nose, and it come back he'd been eating donuts at Dairy Queen. So the other issue, though, in this case is we have an administrative process that says if you refuse, you lose your license for 6 months automatically. And that's got some interference with the constitutional decision, I am of the opinion, that came down from the Supreme Court. So I don't believe this issue is going to go any further than where it is, because the Supreme Court says it's a constitutional, your Fourth Amendment right to not have that piercing, the way I read that case. And so I look forward to working with you, Representative, to try to get the problems worked out. And we need to get this statistical information also to see how we can slow down to not punish people that are, and I don't want to go on no more than what I've said. I could get you plenty of them, but try to take it all up at one time so we can have some remedy to make this thing more balanced. I like no better than anybody else to punish people that are doing something wrong that she shouldn't be doing. I do take a little exception, though, that a good lawyer would say, if you got something in your system, you better not take it. But if you don't have in your system, you better take that blood test.
If you don't.
That's what a lawyer will tell them. I've told many of them that because it's proof that they're not got anything in their system. So I look forward to working with you to try to have some input in this. Thank you for your presentation, though.
Can I say just very briefly, as you well know, we don't have the equivalent of a PBT yet for drugs, and hopefully we will, and that will help address the concern you have about those who don't have anything in their system, drug-wise, being arrested.
Well, I'm hoping we can add some expediency to the return in special instances instead of waiting 6 months and all that. That's and I've seen it all. So thank you very much for your your concern and your presentation. I really appreciate that.
Senator West.
Thank you, Mr. Chairman. Thank you for your presentation. My question regards the legislation passed in other states that allow a search warrant in the case of refusal. Do you know, have those laws been tested yet in the courts?
I'm not aware of any, but I'll defer to the people to my left and right if they have any knowledge of that.
It is my understanding that that's good law, that
yeah.
Every state that has it, it's still the law in those states.
Gotcha. Thank you.
Representative Nemes, last question.
Thank you, Mr. Chairman. I do want to note that when we say the Kentucky Supreme Court did something, it was a 5-2 opinion. Justice Van Meter and Justice Conley dissented. It's rare that we have dissents in the Kentucky Supreme Court, so I wanted to call those two justices out for, I think, doing good work. The case that was referenced is from North Dakota. It's Birchfield versus North Dakota. I'm going to read just 2 sentences from that opinion. This is the United States Supreme Court opinion that our Kentucky Supreme Court got wrong. It says, our prior opinions, talking about the U.S. Supreme Court, our prior opinions have referred approvingly to the general concept of implied consent laws that impose civil penalties on evidentiary consequences on motorists who refuse to comply. Petitioners do not question the constitutionality of those laws, and nothing we say here should be read to cast doubt on them. Our Supreme Court just got it wrong. My question is this. It could take a long time for the U.S. Supreme Court to determine whether they grant cert, and if they do, there's the briefing process, which is months for both sides, and so it could be a year and a half. It seems to me from your testimony that we're under a situation of emergency, and I don't understand why we're only doing the search warrant thing. I think we also need to go on implied consent. Remember, driving is not a right. When you get your license, you consent to some things, and one of those things has always been that you'll take the blood test. And if you don't take the blood test, then the prosecution can inform the jury of you not taking the blood test. You still have the right to say no. The prosecution can then inform the jury on the truth of the matter. So I don't understand why we're waiting. I understand the subpoena issue or the search warrant issue that we're trying to resolve here. But why are we also waiting on the other question, which is that the prosecutor should be able to inform the jury of the truth of the matter, that you violated the consent that you've impliedly given when you got the license, and such that the prosecutor can inform the jury that you said no to the test? Why are we waiting?
I'll make an attempt to address that. That is an issue that has been discussed in our informal meetings with the County Attorneys Association and prosecutors. So I understand where you're coming from on that, and be glad to talk to you about that. This is not a finished product. The bill, I'm planning on pre-filing a bill, but there are some issues that I want to get comfortable with before it's pre-filed. So I would welcome your input on that, and anybody else on this committee or any other members of the General Assembly.
Thank you, Mr. Chairman.
Yes, sir. Representative, thank you. Ms. Tapke and Mr. George, thank you.
Thank you.
All three.
Thank you.
Appreciate it.
Thank you for allowing us to be here.
Yes, sir. Our next presenters are from the organization Supporting Heroes. We have Executive Director Eric Johnson with us and Chief Kyle Smith. Are you flying solo today?
Well, he's here, but he's not speaking.
Gotcha. Well, you have the floor, sir.
This on? No.
Push the...
Okay.
There we go.
Well, thank you. Thank you for the opportunity to be here and to tell about the important work of Supporting Heroes. My name is Eric Johnson. I'm the Executive Director of Supporting Heroes. And I've served in that capacity since the organization began operations in 2004. I'm also a retired first responder with 27 years of service, 9 in EMS and 18 in law enforcement. Supporting Heroes is a 501c3 nonprofit organization whose mission it is to honor first responders who fall in the line of duty and to support their families. Supporting Heroes was founded and is headquartered in Louisville. We began operations on September the 11th, 2004. We chose that date to capture the symbolism of what we all witnessed during the attacks on our nation 3 years earlier. As we watched in horror that day, as so many ran from the towers, we also witnessed countless brave men and women going toward the towers and most certainly into harm's way. Just as it happens on a smaller scale in communities across Kentucky every minute of every day. For the past 17 years, Supporting Heroes has been responding to line-of-duty deaths of law enforcement officers, firefighters, and EMS providers in all of Kentucky and all of Indiana. And for the last 5.5 years, we've been doing the same in Missouri. Even though we've been serving for over 17 years, it is quite possible that you have not heard of us before now. That is because our focus has been on service and to do so with humility and transparency. Also, our fundraising has primarily been geared toward first responders and not as much to the general public. Before I get into the specifics of what we do, I want to give you some perspective on how often we respond to a line of duty death and how that has been impacted by the pandemic. Needless to say, the last 20 months have been the most difficult in our 17-year history. Prior to the pandemic, we responded to a line of duty death on average once every 21 days, which is an average of 17.5 deaths per year in the 3 states that we serve. In Kentucky, it was an average of once every 56 days, or 6.5 deaths per year. When I submitted the information for this presentation this past Friday, there had been 70 line-of-duty deaths in our 3 states over the previous 365 days. Again, 70 compared to the pre-pandemic average of 17.5. 30 of those were in Kentucky. 25 of the 30 were from COVID. There's also something else I want to say before getting into the specifics of Supporting Heroes. And please believe that what I'm about to say is not in any way meant as criticism of government. It is simply a statement of fact and will set the stage for the information I'm about to give. When I first became a first responder in 1977, I believed, like so many others who serve, that if someone fell in the line of duty, be it a law enforcement officer, firefighter, or EMS worker, the government would step in and do great things to support the family. And I believe most citizens think that as well. But that's simply not the case. There are some things government does well, but it would be difficult for the government to do what I'm about to describe. As I describe what our organization does, I hope you'll agree that the services we provide represent the types of support our first responders deserve, and most importantly, what the families of those who give their lives in the line of duty deserve. You'll also notice that there are some things that we can do as a nonprofit that are the right things for families, but that would be difficult for government to do. Certainly not with the flexibility that is needed in the wake of a tragedy to serve the specific needs of a family. Supporting Heroes is built on 2 foundational principles. Number 1, those who routinely go into harm's way for others should have comfort in knowing that, if they should fall in the line of duty, their families will be well cared for. And number 2, no life is more important or less important than another. It doesn't matter if someone is paid to serve or does so as a volunteer, whether they are from the largest department or one of the smallest, whether they serve in the biggest city or the smallest community, whether or not they're a member of a union, an association, or any organization. None of those things should matter. It also should not matter how dramatic or undramatic the circumstances of their death might be. When someone gives his or her life in the line of duty, it is the ultimate sacrifice. That individual should receive the highest honors, and his or her family should be well cared for. Quite simply, that is our mission: to honor the service and sacrifice of public safety heroes who give their lives in the line of duty by caring for the loved ones left behind. So what do we do? First, consider that in addition to the grief, shock, and even anger that we expect to be felt by a spouse after a first responder has fallen, more often than not, they also experience immediate financial stress after the main or only breadwinner of the family is suddenly and tragically taken away. They wonder, how am I going to keep our home? How am I going to feed our kids? And it's not uncommon for these questions and the accompanying financial stress to be followed by significant feelings of guilt, as many survivors berate themselves for, quote, thinking about money at a time like this, end quote. Our commitment is to have representatives en route to a line of duty death as soon as possible following notification, prepared to remain in that community until after the funeral, which is typically a week or more. As soon as appropriate, following the guidance of leaders of the agency, our representative will meet with the immediate survivor and present a $5,000 emergency funds check, along with an offer for additional emergency funds if needed. Our goal is to take financial stress away, whatever that means for that family, and free the immediate survivor to focus on what is most important: their family, their grief, and healing. We let the survivor know that the check that we present is a down payment on a promise. Our promise that we'll be there over the days, weeks, months, and even years to come. We then commit to meet with the survivor days after the funeral to assess financial need. Based on that assessment, we provide ongoing monthly support according to need as we assist with filing for benefits. This support often enables a now single parent to take a leave of absence from their job and be a full-time stay-at-home parent. If you consider that most employers typically give employees 3 days off following the death of a family member, just imagine the spouse of a fallen hero going back to work in 3 days, functioning normally while dealing with their own grief and that of their children. And I want to clarify something about the individuals we support. And this is one of those areas where we have flexibility that the government wouldn't. You'll recall from our mission statement that we care for the loved ones left behind. I'm certain you'll agree that loved ones are not always defined by legal relationships. We determine who the loved ones are by looking at not just legal relationships, but living arrangements, and by talking with family members, friends, and coworkers. In some instances, our support might go to more than one individual, such as a cohabitant or even an ex-spouse for the care of the hero's children, or possibly to parents, such as when a first responder has been helping to care for sick or elderly parents. Again, our mission is to care for the loved ones left behind. And each fallen hero tells us who his or her loved ones are by the way he or she lived. We provide ongoing financial support, again according to need, until the first significant benefit is received, such as insurance proceeds or state or federal benefits. While it was never envisioned that we would have a role in filing for benefits, we have grown to specialize in public safety officers' benefits, the line of duty death and disability benefits of the federal government. We now file 80 to 90% or possibly more of all PSOB death benefit claims from our 3 states, and we have for several years. In recent years, we've also assisted with filing for state benefits, but not at the same rate as the federal. We maintain a specially trained memorial team. Our initial responding representative will offer the assistance of the team to whatever degree is desired by agency leaders to help with the funeral and rendering of professional honors. Our goal is to free the members of the affected agency to grieve and to bring a level of expertise that only comes with experience, with significant experience and training. The members of our team are mostly volunteers and are active or retired first responders from across the region. Some are even survivors of fallen first responders. We also work to connect survivors to peers by holding events throughout the year to bring families together so that relationships among peers will form or be strengthened. Widows meet and support other widows, parents support parents, etc. We bring people together who understand, as only those walking a similar path can. Also, each year, national memorial services are held to honor the men and women from each of the 3 service fields who fall in the line of duty, who fell the previous year. National Police Week in Washington, D.C., National EMS Weekend of Honor, also in D.C., and National Fallen Firefighters Memorial Weekend in Emmitsburg, Maryland. Tragically, before supporting heroes, many survivors missed when the nation honored their hero because they could not afford to attend. Since 2006, Supporting Heroes has funded travel and lodging for immediate family members to attend the national memorial services when their loved one is honored. Kentucky Cops assist with some of the expenses for Kentucky police families, and occasionally unions or other organizations provide some direct assistance. But our commitment is to cover everything else. Supporting Heroes funded $119,000 for the National Memorial Services in 2019, and while we don't yet have final numbers for 2020, for this year, well over $200,000 were spent, which this year's services honored first responders who fell in 2019 and 2020 since the 2020 services were canceled. We provide the support to ensure that each immediate family member is able to be present when the nation honors their hero, and to ensure that they have opportunity to see and touch their loved one's name on their respective national memorial wall. While they're there, we provide 24-hour shuttle service to take survivors wherever they need to go, whenever they need to go. And members of our staff and volunteers are there to provide support and assistance as needed. We want to demonstrate in a substantive way that honor for their hero did not end at the grave, but that it endures as we support them during their journey, and that it will endure into perpetuity at the National Memorial even after they have returned home. For families, there are times when a hero's absence is most palpable, year after year: birthdays, Thanksgiving, and Christmas. So just after Thanksgiving, we send a wreath to each family, not just the first year, but ongoing. A hero's sacrifice is forever, so is that of the family. On each child's birthday until they turn 19 or graduate from college, we send a card and a check for $50. It isn't much, but it lets them know that they and their hero parent are not forgotten, that their parents' sacrifice meant something, and that people remember. At Christmas, we send each child a check for $100, along with a letter written specifically to that child, emphasizing that his or her parent was a hero and made a difference in many people's lives. Quite simply, our mission is to do everything we can to support families following the line of duty death of a first responder. In the wake of a death, we actively look for ways to help in that particular situation for that particular family and agency. As you might expect, every family, every agency, and every tragedy is different. To illustrate some of the ways we're responsive to tragedy, consider the story of the mother of Officer Jason Ellis of the Bardstown Police Department, who was shot and killed on his way home on May 25, 2013, and whose murder still has not been solved. While this story is specific to Officer Ellis's mother and his family, it is representative of many others. At the time of Officer Ellis's death, his mom and husband were in a camper in a remote area of North Dakota. After the terrible news was delivered by a local sheriff, she called the number she had been given to talk to a Bardstown police chaplain, no doubt in hopes of finding that the news she had received was not true. After they talked for a few moments, I heard the chaplain say, "Ma'am, I don't know, but there are some people here who I think can help." He then covered the phone and said, "She wants to know how she can get here." I replied that we would take care of it. I told him to get her and her husband's information for TSA, determine the nearest airport, and we would make the arrangements. We then set about booking the next and best flight out of Minot, North Dakota, to get to Louisville, Kentucky as soon as possible. After making the arrangements and paying for the flights, we directed her and her husband to a location away from the airport where they could park their camper and meet local law enforcement for transportation. At the airport, the officers accompanied Mr. and Mrs. Deerwester through security and remained with them until they boarded the flight. When they landed in Minneapolis, there were uniformed police honor guards waiting as they deplaned. The officers escorted them to the Delta Sky Club, where an area had been set up just for them, and where they were treated with honor, respect, and compassion while they waited for their next flight. When it was time, the honor guards escorted them to the gate. The Deerwesters then flew to Atlanta for their connection to Louisville. Here again, uniformed police honor guards were waiting, and they were again escorted to a special place and treated like royalty while awaiting the next flight. When they arrived in Louisville, passengers were asked to remain seated as they exited the plane. They are escorted through the door and down the stairs from the jet bridge to the tarmac and to an awaiting police car. Their bags were pulled from the belly of the plane, and they immediately left for Officer Ellis's home. When they arrived there, a rental car was waiting, ready for their use. There were also hotel keys, one room for them and one each for Officer Ellis's sisters, who were traveling from Ohio with their families. These things were done as a means of honoring Officer Ellis by caring for the loved ones he left behind. I could tell more about the services Supporting Heroes provides and the standards by which we serve, but I hope from what I've already shared that you agree that Supporting Heroes provides important services that the families of Kentucky's fallen first responders deserve, and that provides comfort to each first responder that, should they fall in the line of duty, their family will be well cared for. We thank you for the opportunity to come today and tell about the important work of Supporting Heroes. In closing, there are some things I would like to ask. First, if you believe that what Supporting Heroes does is worthwhile, we hope you'll help spread the word. We need support now more than ever. And if you really like what you've heard, we hope you become a member. There's information in the brochure that was emailed to everyone. But most importantly, we respectfully ask for the opportunity to discuss ways that we can work together to better serve families of Kentucky's fallen first responders. Responding to all line of duty deaths in all service fields in Kentucky, as well as all service fields in 2 other states, working heavily with the federal benefits, generally studying line of duty death well beyond our 3 states, and most importantly, serving Kentucky survivors for over 17 years, gives us insight that could help the Commonwealth serve families better, without added costs. Although we would like to see Kentucky's $80,000 line of duty death benefit increased, more importantly, we would like to discuss ways it could be better standardized, streamlined, and when approved, dispersed in a manner that would better help those who were financially impacted by the hero sacrifice. We see what we believe are unintended consequences of the current law. For example, specifically in regard to standardization, Kentucky law currently provides for each service field, police, fire, EMS, and corrections, to establish its own definition of line of duty death and its own set of criteria for approval and procedures for review. One of the unintended consequences is that there are unequal standards. Circumstances that might be considered line of duty and eligible for the state benefit in one service field would not necessarily be considered line of duty and eligible for the benefit in another. We are confident that this is not what is intended. Again, we ask for the opportunity to discuss these things and more, with the goal of making Kentucky's support for the families of fallen first responders the best it can be and a model for the country. Again, thank you for the opportunity to be here and to share this important information.
Mr. Johnson, thank you. I appreciate the presentation. I'll also direct members, if they're interested in learning more, to supportingheroes.org, which I believe is your organization's website.
Yes, sir.
The 3 states, you're in Indiana and Missouri as of a few years ago?
Yes, correct. We jumped over Illinois, but that's nobody, yeah, you don't want to.
As a graduate of SIU Law School, I don't blame you. Skip right over and go right to Mizzou.
Absolutely.
I appreciate the presentation, and I appreciate what you do. There's no risk and no harm of overdoing our response for first responders and the family of first responders, particularly when they've been lost in the line of duty. So I'm thankful for the ministry work that you're doing and for the staff, the people there with the organization, with Supporting Heroes, and what you're doing in all 3 states. Senator Carroll.
Thank you, Mr. Chairman. Eric, it's good to see you, my friend. I have known Eric and been familiar with this organization probably about 30 years now, and I have seen the work that they do firsthand through some deaths throughout the state while I was a police officer. And this organization is the real deal, and it's not its mission is its mission, and he means what he says, and it is just invaluable to the families that are going through the death of a loved one. And I think this organization is worthy of all of our support. And Eric, as far as what's needed to help with these benefits, it would probably be beneficial to us if perhaps you all could put a one-pager together and kind of summarize the changes that you feel would be beneficial to our families who are survived, or who are surviving the death of a loved one, and that might help us to formulate some legislation that might streamline some processes and allow you all and to provide better services and allow our surviving families to be better served. So that's one recommendation I would make, if you could just more formalize that in writing so we could perhaps generate some legislation.
We could do that.
Okay.
Thank you, Senator Carroll. Any other members? Seeing none. Thank you again, Mr.
Right.
Johnson.
Thank you very much.
I appreciate your time and appreciate you coming. All right, our final presentation is from our friend and member, Representative Kim Moser, on an update to Casey's Law, which has been on the books for a number of years here in Kentucky. Glad to have Representative Moser with us. We also have Blake Christopher with the Office of the Attorney General, Deputy AG Christopher, or Deputy General Counsel, excuse me. We're glad to have you. Good morning. Good to see you again, Ms. Weddington. And I believe we've got a video presentation. We're going to get that going here. Representative, you have the floor.
Thank you so much. Good morning, or good afternoon. Thank you for the opportunity to be with you today and to talk about a bit of a cleanup to Casey's Law. And as you said, it's been in effect for many years. The Matthew Casey Weddington Act for Substance Abuse Intervention became law in 2004. The law was a response to the tragic death of Matthew Casey Weddington, who died of a heroin overdose at 23. Casey's mother, Charlotte, is here with us today. I am so grateful for her advocacy through the years. She's done amazing work. This law is saving lives. And this is Casey's legacy, and we want to strengthen it. Since 2004, there have been nearly 6,000 cases of Kentucky citizens using Casey's Law. Many of them have resulted in life-saving, court-ordered treatment. We believe in Casey's Law, and we want even more victims of substance use disorder to get the treatment that they need. The same kind of treatment that so many families are desperate for. We do have some changes that we want to discuss, and we have a short video.
While he's getting that ready, I want to extend the committee's thanks to Ms. Weddington. I'm glad you're here. I didn't know you were going to be with us. We would have put you on the agenda, but I'm glad that you're here, and I'm thankful for your hard work and tireless work over a number of years, not just to create the law in the first place, but to see that changes are made and improvements are made so that more people can be helped and more interventions can be done to spare lives. So thank you.
Okay, you ready? We're going to try. Here we go.
My experience might have been unique because I was at the facility with Charlotte Weddington, with Casey's mom, and every day I saw this woman who wanted her son back. And I started looking at my mom like that. And over months and over days, that anger and that resentment dissipated. And, you know, things got better. The one thing I always hear, the addict doesn't get it until he wants to get it. Well, you know, yeah, of course you're right, but maybe the addict doesn't know he wants it. So if we're looking at this from that angle, maybe the addict doesn't know he needs help. Well, of course he doesn't, because the only thing he thinks he needs is one more. You know, they probably do need to be pulled out of the community, you know, without convicting them of a felony, without sending them away. I did. I needed to be uplifted and put somewhere safe where, you know, in a controlled environment where, you know, direction and guidance and love was given to me. Casey's Law changed my life by introducing me into a community of advocates and networks that solely revolved around getting addicts and alcoholics help. By how it's changed my work. Up until I was case law, I never worked a day in my life, not legally. I was one of those street hustlers. If it wasn't strapped down, I was taking it, I was reselling it, I was picking up, and I was getting into the streets. I was selling drugs to buy more drugs I was going on a nowhere fast. When Casey's Law was filed against me, it introduced me to recovery. It reunited me with my family. I'm back into college. I'm going in for social working. I've picked a career that is, targeted at helping individuals get out of their circumstances. And it might have taken 7 years since the initial filing, but I'm finally at in a position where I am a good father, I am a good son, I'm a good student, and I'm a asset to my community. Of course, I felt my rights were violated. But that feeling isn't unique to Casey's Law. I felt my rights were infringed upon by every time the police have come and picked me up. I felt like my rights were infringed upon every time my parents took my keys so I wouldn't drive high or drunk around the community. When I'm out actively using, the only right I care about is the right to put substances into my body. And I will violate yours to do it. So, Casey's Law, yeah, I felt it violated my rights, but I feel like every time the police intervened on me, or the ambulance and the EMTs, yeah. Luckily, my rights are allowed to be infringed upon if I'm acting out in a way that it could kill somebody, and that includes me. You took away the only thing I wanted to do in my life. Luckily, you gave me something to do in the meantime, which is recover or go back to jail. I had a choice. I didn't want to. Jail didn't look good. Honestly, at that point in time, getting high was kind of getting stressful, you know what I mean? And I don't know how to live sober. So thank God that this sentence came across as, look, instead of giving you a felony and giving you probation and making you take drug tests once or twice a week for the next 3 years, we're going to put you in a facility. We're not going to give you a felony. And we're going to teach you how to not fail a drug test, which is like the only way to fail a drug test is obviously getting high. And we're going to teach you how not to do that. Because when you just take it away and you don't give me anything else to do, that's a recipe for disaster too. The only difference between, substance abuse treatment, JSAP programs, and, Casey's Law is you can do Casey's Law without ruining people's lives.
When I first learned about Casey's Law and its enactment, I didn't have any particular preconceived notions about it. I did have some skepticism at that point in time about whether or not court-mandated involuntary treatment for substance abuse was, in fact, effective, or could it be effective? But as time has went on, and as I have seen more and more examples of success, my opinion about that has changed in a pretty significant way. And one way that, if you think about it, I think the success rates are probably pretty comparable or maybe just a little better than people that voluntarily go into treatment, because one of the things that an addict needs is accountability. And you can't, if you just voluntarily go into treatment, you can walk away from that at any time. And you don't have particularly anyone that you have to account to other than yourself. And quite frankly, those persons are not thinking straight anyways. That's something that the court can provide for them. They can provide the accountability, they can provide the follow-up, and that's what we try to do when a Casey's Law petition is in fact filed. Anyone that may be warily eyeing the prospect of increasing the use of Casey's Law in your jurisdiction, or even perhaps starting to use Casey's Law in your jurisdiction for the first time, I would encourage you to do so, because I believe that it does work. Anybody that's been involved in the criminal justice system for any period of time understands that substance abuse is one of the major drivers of the overcrowding of our jails and our prisons, the depressingly high rates of poverty in our communities, and the destruction of families. We must try each one at a time, each individual at a time. And for the ones that we are able to help and the success stories that you see, that's worth it all.
All right. Well, thank you for indulging us. I felt like it was important for you all to see the actual impact on individuals and kind of their line of thinking. So I'll allow Blake to introduce himself and talk about some of the changes that we think will strengthen Casey's Law and clarify any questions for judges who seek to use it.
Thank you, Representative Moser, and thank you to the committee for inviting us today and for your time today. I look forward to your questions, but before we do that, just wanted to run through a little bit of our thinking in what is motivating these changes and why we think they are necessary to ensuring the preservation and the enforcement of Casey's Law throughout the Commonwealth. So I want to point out that we all in the Attorney General's office believe very dearly in Casey's Law, and we believe very dearly in defending the laws passed by the General Assembly. But there have been challenges to the enforcement of this law. There have been repeated constitutional challenges in courts around the Commonwealth, and as a result, there are several counties in Kentucky where you can't get a Casey's Law petition heard. And because of confidentiality concerns, I won't go into which counties exactly those are, but I think it's safe to say that they're in some of the regions that are hit hardest by the drug epidemic. And why are these places not hearing Casey's Law petitions? Well, it's because they have concerns about the constitutionality of the law. And the AG's office is currently defending Casey's Law in the Kentucky Court of Appeals in a confidential appeal right now. So all this begs the question, well, what are our thoughts on addressing this issue? And why are we here? Well, I think we're here for two changes that we think will help address these concerns. And ensuring that victims, no matter where they live, victims of the substance use disorder, can get the help they need. So those changes are these, and I'm happy to take questions on them in a moment. The first is to create a beyond reasonable doubt standard that a petition must meet before someone can be committed to court-ordered treatment. The second is to allow someone up for commitment to cross-examine the healthcare professionals who examined and submitted written testimony about him or her. Let's talk about the beyond reasonable doubt standard first. Casey's Law currently provides, and I'm going to speak very generally, but I'm sure most of you know that Casey's Law currently provides for two kinds of hearings, if you will. The first hearing, the judge examines the documents that are filed in the record, usually the petition, and questions the petitioner, usually a family member, about the need for the son or daughter or sister or brother to receive court-ordered treatment. In the second hearing, the judge determines whether to order the court-ordered treatment. Currently, Casey's Law establishes a pretty clear burden of proof for that first hearing as probable cause, which, as we all know and has been discussed today, is a pretty low standard. However, there are some who argue that Casey's Law is a bit unclear about what the burden of proof is for that second hearing, which is where the judge actually orders the commitment. Now, we don't think that that argument is correct. We think that the standard for the second hearing is not necessarily unclear, but we do support amending the law to clarify what we believe is already clear to us. So our first change would create a beyond reasonable doubt standard for that second hearing. Right? The judge would have to find beyond reasonable doubt that there is evidence necessary to commit someone to court-ordered treatment. We think this is fair given the civil liberties that are at stake in these hearings, but we don't think it will necessarily discourage petitions from being sought, nor do we necessarily think it will impact the number of individuals who qualify and receive treatment. As I said before, and as I will continue to say, we are all believers in what Casey's Law does, and we want people to be able to get the treatment that they need. And we don't think that this standard will necessarily disincentivize or chill folks from either seeking the petitions or will discourage the number of those who can qualify for commitment. In fact, there are many judges who are already using a beyond reasonable doubt standard, and I'm happy to talk about that already, or later, I should say. So we'll move to the second change. Casey's Law requires, as I'm sure all of you know, 2 qualified healthcare professionals to submit written testimony. One of those healthcare professionals must be a physician. And then later, there's opportunity for the judge to examine the written testimony and ask questions to those who have submitted their findings. We believe that under current law, if the individual up for commitment wished to subpoena those qualified healthcare professionals and cross-examine them at the commitment hearing, that he or she could do so. But there are those who disagree and say that Casey's Law is deficient for not stating so specifically or not including a cross-examination process in the law itself. So the second change would simply write into the law what we believe to already be true, that the individual up for drug treatment can subpoena the healthcare professionals who have examined him or her and who have submitted written testimony about his or her condition. Again, we believe that Casey's Law is constitutionally sound as it is, but we think that there is a problem that is arising and is increasingly becoming more of a concern, that those who disagree are leading to places in Kentucky where you can't get these petitions heard and where folks can't get the help that they need. And we think there's a middle ground here to be made where we can address some of those concerns that we're seeing while preserving the intent and the impact of what Casey's Law does and the important work that we all know that it does in a great many communities across the Commonwealth. So to conclude, we think our changes will help ensure that Casey's Law can be enforced, that it can be preserved, and that victims of substance abuse disorder can get the help they need no matter where they live in the Commonwealth. And with that, I'll happy to take any questions or follow Representative Moser's lead.
Okay, thank you so much, Blake. And I don't know, Charlotte, if you wanted to add anything or say a few words.
Well, I'll turn my mic on. Casey's Law has been in effect for 17 years, and in that 17 years, there have been hundreds of individuals whose lives have been dramatically changed and who are now living in recovery in part because of Casey's Law. I never give Casey's Law credit for the total recovery, because if you are familiar with addiction and recovery, you know that it is a lifelong journey and it takes a lot of work to recover. I know that everyone that I have ever talked to who has been petitioned under Casey's Law into treatment has been grateful. There has not been one person to say, oh gosh, I hate my life in recovery. I wish my family had never done this to me. They are more than grateful. I've had the privilege of traveling around the state and visiting recovery treatment facilities and with people who are there under Casey's Law. And I am greeted with hugs and smiles and thank yous because they have now a chance to live a life that they never thought would be possible. I know that having lived with Casey, that he had gotten to the point that he could not make a rational decision for himself because his brain had been damaged to the point that the systems in his brain were not communicating with each other. He had a system in the midbrain that was saying go, 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 and that prefrontal cortex, that's our control panel, was not working. The stop system was not there. So I know that he could not make a decision to get help. Just recently, there was a middle-aged man actually who passed away, a friend of mine, who had actually been in the center, and he had had a recurrence of his disease. And his question to his family member was, how did I get here? Because no one intends to get there, but that's the nature of the disease of addiction. So I feel like, that I don't know where we would be. I don't know where we would be at this point if not for Casey's Law. My opinion is that we would be seeing more obituaries in the paper that were a result of addiction, because this is an issue that affects. I have never talked to anybody, I don't think, or 9 out of 10 people that I've talked to that have not had a story to tell me when I have told them theirs, because it does affect so many people, and we are losing more and more people all the time. If we ever needed Casey's Law, certainly we need it now more than ever before. And it should not depend on where you live as to whether or not you have access to Casey's Law. We want everybody to have access to a law that can really bring hope and help to people who need, and I would add, deserve the treatment. And so I thank you for the opportunity to be here. I would be glad, to answer any questions that I might answer about how it's impacted our communities. But thank you. Thank you.
Thank you, Ms. Weddington.
Thank you, Mr. Chair. We are happy to answer any questions.
We've got one so far from Senator Berg, and before I let her ask her question, I want to point out and sort of follow up with your remarks, Ms. Weddington. Just this morning, on my way up, I got a notification on my phone from both the Washington Post and I pulled up the Post, so I don't know. Looks like, the Wall Street Journal. But new data came out just today. 100,000 Americans died of drug overdoses in 1 year span. One of the highest numbers, or maybe the highest number on record. It continues to be. You said if there was ever a time that we needed something like Casey's Law around, it's now, and you're right. And that it triggered my memory of that notification that I got on my way up this morning. All opioids was 75,000. Synthetic opioids was 64,000. All drug deaths combined was over 100,000. Very timely presentation, and again, I appreciate your advocacy. Senator Berg.
Thank you.
Thank you, Chairman Westerfield. And again, I have a comment, not a question. First of all, I'm extremely sorry for your loss. But I just wanted to say, you said that you think hundreds of people have been impacted by this law in the state of Kentucky. And I can promise you that is a drastic underestimation of the number of people that this law has impacted in a positive way. I mean, I myself have 2 family members that went into treatment under the fear of Casey's Law, just saying, if you don't, we will. And it gives families a tool that is desperately needed. Anything we can do to strengthen this law in this state and make it apply equally throughout the state, I'm 100% in favor of. And I just can't tell you how awed I am to be sitting here in your presence, because I know, it's through great tragedy, but you have made a tremendous impact on this state. And I thank you personally and sincerely.
Any other questions, comments? See, I'm asking for comments now. We got a few minutes left. Yes, Senator Carroll.
I appreciate the work, and I throughout my life I've seen this a lot, and even within our family, and he would not object to me saying this. I know a brother-in-law that I hated for him to be in my house and felt like I had to during the holidays, and I despised him for what he did to his parents and to my wife. and never thought he would get clean. Today, he's one of my best friends. And so sometimes it does take forcing the hands. And in today's world, the problem's not, we're focusing so much on treatment, and that's of no value if we can't get the people into treatment. So I support what you're doing, and look forward to supporting this bill.
Thank you.
Thank you, Senator. Seeing nothing else, thank you, Representative. I appreciate it. Thank you, Ms. Weddington, again. Thank you, Mr. Christopher. I appreciate it.
Thank you so much.
I believe this concludes our interim calendar for 2021. I don't anticipate a December meeting. Thank you, Mr. Vice Chairman. I appreciate that. I look forward to January. I'm sure everybody else does as well. Members, if you have questions or if staff can be of resource to you over these last several weeks, I know Roberta and her team. We actually have, Roberta, do you want to say the names of our new folks? Because I don't think I've introduced our new folks.
They are here with us today.
Excellent.
Right over there, Miss Lexington Sowers and Miss Stacy Burns-Talby.
So members, those present and remote, those are our two brand new analysts here. Have no idea what we just suckered them into. Man, right before a long session, too. That's just cruel and unusual. Talk to the guy right behind you there. He can give you a little insight into what kind of just catastrophic mistake you've just made. We're glad to have you. We like to pick, but this is the best committee in the building. Do you hear that, John Snyder? Best committee in the building with the best staff in the building, and does, I think, the most important work, or some of the most important. I guess the budget's pretty important. Health and welfare, that's pretty important. But I'm pretty partial to the work that the Judiciary Committee gets to do, and I'm thankful to have you on board. Anything else, members? Any announcements? Mr. Vice Chairman, anything?
Mr. Chairman, I've told you this several times. This is my favorite committee, and the discussions that we get into, and always differing opinions, but it's always productive discussion, and I'm honored to be a part of this.
Thank you. Yes, Representative Hebron.
Thank you. I just want to take a second to really brag on our staff and echo the comments of the chairman. Man, Roberta Kaiser, if I had a best friend up here, she would be it. She really just takes such great care of us, and I greatly appreciate that. We would not have the interim be possible and session be possible without our great staff. So thank you to each of you all. We appreciate you, especially this month of Thanksgiving. Thank you for your time commitment that you give to us.
Well said. Right on the money. All right, seeing no further business before the committee, we are adjourned. Happy Thanksgiving. Merry Christmas.